to our weekly video. Today I'm talking about the Homeowners Association foreclosures and the main issues that we're seeing with those foreclosures from a legal standpoint. So the first question people have is, how come the Homeowners Associations have the power to sell somebody's property at foreclosure auction? And that's a good question because I find it a little bit odd myself, but that's just how it's set up here in Texas, where the Homeowners Association have that power to sell the property. And that's always stated, always outlined in the governing documents, which are also called CCR, which stands for Covenant, Conditions, and Restrictions. And as we all know, the covenant means promise, and so that's just the promises that the HOAs make to keep the common areas in good shape and to a certain standard and to help with certain things. And then the homeowner on the other hand makes a promise to pay a certain amount every month or every quarter or as needed to contribute towards those services that will be provided. The conditions are things that must happen before another thing happens. So if A, then B, that will be a condition. And that's typically including things that you can do with the outside area of your property, or maybe even with the inside area, but you have to get permission of the Homeowners Association to do that. And then the restrictions are things that we absolutely cannot do if we live in a community. And some of those things will be, oh, you cannot choose a certain color to paint your house on the outside or to paint your fence. And sometimes restrictions on whether you can run a certain type of business from inside your house. And most times it's going to be something to do with daycare business or things like that. So anyway, that's pretty much what those documents would be, and they're called CCRs or governing documents. And the Homeowners Association is typically established at the onset of that development. So when they're starting out building a few properties at a time, which is what builders do, or developers, they build in trenches. So they do one set of houses, then get the financing to do the next step of houses, the next batch of houses. So they usually have an association set up once they've completed a couple of batches, and they see, oh, we want everybody to keep their lawns a certain way, or this would be nice to have, to make sure everything looks good. So that's the genesis of the Homeowners Association. The CCRs will be something that you'll receive as a homeowner once you move into a community, and during the contract process before closing, they have to give you all the information about the Homeowners Association, and you have to review them to see if you are happy with them or not. Some homeowners associations do not have the power to sell, but it just depends on the area. So make sure you consult with a lawyer in your local area to see that you fully understand the powers of the Homeowners Association in your community. In those same documents, the governing documents, they have the provision that allows the Homeowners Association to move forward with a foreclosure sale if I fail to pay on the assessment. And that is something that most people are not aware of when they move into a community. But here in Texas, a lot of them do have the power to sell the property, and inside those governing documents. The power can also be differentiated in a couple of ways. Some of the provisions in some documents for different homeowners associations will say that they can move forward with a foreclosure without court intervention, without going through the judicial process. And for the other ones, if it doesn't say specifically, then they must do a judicial foreclosure, which means that they go to court, they sue me as a homeowner first, notify me according to civil procedure, for due process, and then follow all of the processes of the court before they can then get an order for foreclosure and sell the property at auction. The non-judicial process skips all of that, and all they have to do is follow certain notice requirements, and then they can move forward with the foreclosure sale. So as far as the timeline goes, most of the time I've already owed on my assessments for at least a year. So sometimes they will issue fines for maybe if I did paint my fence pink, and they don't like that because their rules say that I must choose certain colors, and I went outside of that range. They could fine me if I refuse to repaint it back, maybe to brown or beige or something. That's a fine. So that's different from an assessment. My regular assessment would be usually paid monthly, quarterly, or annually, depending on the area or the management. And the special assessments are for huge improvements that need to be made. Maybe they need to redo the swimming pool area completely. Then they charge, they can get bids and they share with everybody how much they need to make that improvement. And that's semi-urgent, so they have to raise special assessments to cover that. And it's usually a bigger amount. So if I fail to pay on my regular assessments or special assessments, then yeah, they can move forward with the foreclosure. Depending on what's in their governing docs, they can move forward with the foreclosure judicially or non-judicially. Most of them will prefer to do it non-judicially if they can. So if it's in their documents and they can do that, then they'll certainly do that. And then, of course, everybody knows about the different benefits that the homeowners associations will provide, which is keeping the general areas beautiful, cutting the lawn, trimming the hedges, planting flowers, and providing playgrounds, and all sorts of different things. So that's essentially what their promises are. And then we as homeowners will promise to make regular payments on the assessments, okay? Some assessments, it varies by area. Some of them are $50 a month, and some of them are $1,000 a month or more. Just depends on where you live. So that's the background on the homeowners associations themselves. And now, before they get to this part that I'm about to talk about, they probably been sending me collection notices, letters telling me, hey, you need to pay on your account. Maybe they send me emails. It depends on what kind of delivery service I chose. And the homeowner association's management company would send me all these letters. If I refuse to comply, I don't agree with all these charges, maybe because they fined me on so many stupid things, and I refuse to pay my assessment after a while because I think that they're useless. Some people feel that way. Then they finally will file a notice of assessment into the property records, which is usually to let everybody else know that this home has an indebtedness attached to it. So if I try to sell my property, for instance, the buyer will do their own research and they'll find out that I've not paid my homeowners association bill, and they'll force me to pay that before closing. So it helps them in that way. It protects them, it protects HOA. Now, once they do that step, then typically they can start escalating to foreclosure process. If it's non-judicial, there's a set of things that they have to do. It's a shorter process than judicial, understandably. So let's cover the non-judicial first, and then I'll come back in a few minutes to mention how judicial is slightly different. The non-judicial process, so they send me a default notice, which is that final chance for me to cure the default. So for me to fix things and pay, sort out the bill that I owe. So they'll send me a final default notice, and it could be mixed with fines, assessments, penalties, as I said. But the thing that I have to keep in mind as a homeowner is that the fines are fine. The fines are okay. I can fight them on that all day long, and that would not put my property in jeopardy in any way. But the assessments have to be paid. So if I'm nitpicking and not happy with them at all, I don't agree with the way that they run things, I could still look at the bill and say which part of the bill is assessment only and the penalties attached to the assessment, and then I can pay that and ignore the fines, okay? Because the fines are not going to cause my property to be up for foreclosure. Now, when they send me that default notice, I have 30 days to respond or dispute or pay. And I wanted to point out to people, because most people don't realize this, but under Texas law, it tries to protect the home, because that's the biggest purchase that most people would ever make in their lives. And that's a huge thing. It's also a big part of their stability as a family. So the law says that I, as a homeowner, can request a payment plan to get my account current. So the law does say that they must give them a chance to make at least 3 payments. So if I can break my payments up into 3 installments, sometimes people can make that happen. It's easier for a lot of people. So that's what the law says, but there is no maximum time range in the law. So they can allow me to pay for 12 months, but they must at minimum allow me to pay 3 installments. Okay? So I wanted to mention that, and when we negotiate for people, we can usually get a 12-month or 18-month plan. All right. So the other thing that people would ask is, so what happens next? So what happens next is it's up to the homeowners association if they come to the conclusion that they must move forward with a foreclosure against me. Then on the non-judicial path, the next thing they have to do is send me a notice of sale. The notice of sale tells me the date, the place, and the time range of the foreclosure that they're about to do. So in Texas, it's always the first Tuesday of every month. So it will fall on a Tuesday, the first Tuesday of any month. But they have to send the notice out by law at least 21 days before the scheduled foreclosure date. And the time range in there is a range because the trustees at the auction, they have to announce different properties. And so my property might be in the morning group of properties that they'll be selling, or in the afternoon group of properties. So they'll give me a time range, and they must follow through with the foreclosure as the agreed, not agreed, but as the stated date, place, and time range. Or they could be in trouble for not following procedure. So they have to do that. And if they need to make changes, usually they'll cancel the sale, and then they have to then resend out another notice of sale telling me that now the sale has been canceled and moved to another one. So 3 weeks notice to the home on the notice of sale. And then the next step, if the homeowner still does not respond or just miss those documents or the letters for some reason, then they can move forward with the actual sale. When they finish the sale, the law requires them to then send me, the homeowner, a notice of the completed sale within 30 days of that sale date. They're supposed to send me that document, and it's supposed to include language telling me that I have a right to redeem the property within 180 days. So redemption means I'm just trying to get my property back, even though they already sold it to a third party. And I have 180 days to move. It's not a short period of time, but the thing is most people don't even realize that they have that right. So they don't know to do anything. Maybe a buyer should knock on my door and say, hey, I purchased your property, you need to move out. That's when most people realize that, oh, something happened. And some buyers do wait out the 6-month period because they know that their title is subject to the right to redeem. So some of them don't want to speak to anyone or try to go through the eviction process. They just sit quietly for 6 months so that they can get their title at the end. So they don't alert the homeowner to the fact that they purchased the property. They don't try to evict, just so that the homeowner does not exercise the right to redeem, I think, for most people. And some, it's just because they don't want to deal with an eviction process anyway, so they just wait it out and they don't mind losing a little bit of time on their, maybe it's an investment, or they don't mind waiting 6 months to move in if they're trying to use it as a primary residence. Or a lot of times the buyers will let the person know that they purchased the property, they'll try to evict the person, and that's the first time most people would know if they've not been diligently opening their mail and whatnot. So I always tell people it's best to open your mail, especially if it's certified, because these notices will come by certified mail. And if you're not at home, or somehow nobody's at home to collect it, then the postal service usually leaves you a slip telling you to come claim it at the post office. So it's best to claim anything because you have more power if you know what's happening and you have more leverage. You just have more options, and it's always cheaper to fix things at the onset than to try to come back and do damage control. So that's what happens. They're supposed to send me that post foreclosure notice letting me know of my right to redeem, and then the law also requires them to file an affidavit into the property records, the county's records, stating that they already sent me that post-foreclosure notice as the homeowner. Of course, we're finding out that most of the time the homeowners lawyers do not do this. Either they're cutting corners, they're just not following procedure, and they've falling into the habit of not following the procedure because nobody has fought them in the past or nobody has come back to assert their rights. So I'm finding that maybe if there are 10 homeowners association foreclosures, 2 or 3 of them would file the affidavit saying that they completed the post-foreclosure notice requirement, and they will file it within the time period that's required by law, which is within 30 days of the post-foreclosure notice. So within 60 days, they have to do 2 things, 60 days of the sale date. A, they have to send the homeowner a notice of the completed sale, informing the homeowner of the right to redeem, and that has to be done within 30 days of that foreclosure sale date. And then within 30 days of that first notice going out, they then have to file an affidavit with the county saying that they completed step 1. So we're seeing that the affidavits are absent, so we know they didn't do step 1. Or sometimes they'll come back and try to do damage control and file an affidavit 2-3 years later, which is not effective and it's not according to law. So they're not in compliance, and I wanted to make this video to let everybody know these are your rights as a homeowner. If you happen to not know about the foreclosure at all until 180 days have already expired, then that deprives you of your right to redeem under the law. Because normally you would redeem by approaching the buyer. If you were within your 180-day period, you just ask them for proof of how much they paid at auction, and you pay that back if you're within the 180-day period. If it's a little later in the time period, maybe you realize 3 months later, you would owe them interest on top of what they paid at auction. And then you can have the title reverted back. So the title will now be back in your name fully. Okay? There'll be nothing clouding your title. So that will be the process to redeem, but if you pass the 180 days, then what are you supposed to do as a homeowner? So that's why we jump in and we come in at that point and sue the homeowners association if we see that they didn't follow procedure. They didn't follow, especially the part for the post-foreclosure notice. If they didn't follow the right process for the foreclosure itself, then there's wrongful foreclosure. And if they didn't follow the procedure for the post-foreclosure notice, then of course it's also considered wrongful foreclosure in that sense. So they're just different things involved, but essentially they still deprive me of the right to redeem. If they don't send me that notice, right, they potentially deprive me of that. The other question that people usually ask is, well, what if I don't have the money to pay this buyer to redeem the property back? So there's a little trick that I help my clients with when they run into this, because when the homeowners association sells your property at auction, typically you owe them under $10,000, for instance. So let's say you owe $10,000 and the property ends up selling for $300,000. The homeowners association can only keep the $10,000. They hold on to the $290,000, but it actually belongs to you as the owner of that property. So you would be able to get those in what we call excess proceeds, overages, or surplus funds. Once you get that money back, remember, you're getting money out now, and it's a big chunk of money. You'll then have to turn around and pay that to the buyer to redeem the property, plus $10,000, of course, because if you get $290,000 back and that person paid $300,000 at auction, you have to find $10,000 somewhere else and balance it out. So that's how you can raise the funds to be able to do the redemption. If you move fast, the interest is always very little if you're within the 180-day period. It's not really that high, especially if you discover the foreclosure sale quickly and you redeem earlier in the process. So if you need to claim the excess proceeds, we do that at our law firm as well. We can help with any case that's within the state of Texas. And if you're outside of Texas, check with the lawyers in your state to see if your laws allow for that. Okay? So that's how you can do a redemption. You could also, of course, raise money from family members, but you still have a right to collect the excess proceeds from the homeowners association foreclosure sale. The next question people would ask is, well, what's happening to the mortgage in the meantime if I have a mortgage on my property? Well, the law requires the homeowners association to notify the mortgage lender ahead of time before they even do the foreclosure, and also inform them after the foreclosure. But they don't even do that part either. So your mortgage company will sometimes have no clue that it's a foreclosure that's about to happen, or that the foreclosure did happen with the homeowners association. So as far as they're concerned, as long as you keep making your payment, you'll keep collecting your payment on the mortgage. They will not move forward with any foreclosure of their own. But yes, technically speaking, there can be two foreclosures. You can have a homeowners association foreclosure first, and then also have a mortgage foreclosure. The homeowners associations are not they're not prevented by law moving forward with a foreclosure sale just because it's a mortgage on your property. But they're supposed to notify the mortgage company to give them a chance to make things right for you on your behalf, to pay off whatever debt is owed, so that the property does not risk going to foreclosure. But most of the time they don't. Most of the times they don't. So the mortgage company is clueless about what's happening. And if you're still paying on your mortgage, then they totally don't care, because their collateral is still protected. And the reason it's still protected is that the buyer at HOA auction takes title subject to the mortgage as well. So they take title subject to your right of redemption and also subject to the underlying mortgage. And what does that really mean? So they take subject to the right of redemption, meaning that the title to the buyer at HOA auction is not 100% clear title until your redemption period expires, which is the 180-day period, remember? So after that, they have clear title as to your right of redemption. They still have title subject to the mortgage unless you already paid off your mortgage. So if the mortgage is still there in the background, they don't have an obligation under the law to pay the mortgage, but they are exposed to losing possession of that property potentially if the mortgage company moves forward with a foreclosure, because the previous homeowner stopped making the payment. So they will still lose possession. So that's why it's a little complicated, let's say. So I can do a second video to explain how all these things overlap and what happens if the homeowner just walks away and says, hey, they already did a foreclosure on me, thinking that, oh, the homeowners association already did a foreclosure, so I'm not going to make any more mortgage payments. That happens sometimes, and sometimes people continue to make the mortgage payments so that they can redeem the property back. I think the most important question for this particular video is, what if somehow I was out of the country, or in the hospital, or fighting medical issues, and list all these notices, and there was a foreclosure by the homeowners association, and I never received the post foreclosure notice at all. They never did send it. I checked, but I just never received anything, and there's no affidavit that was filed with the county stating that they sent me the post foreclosure notice. And it's now more than 180 days after the sale. What can I do at the moment? Well, I always say it's best to approach things from the least contentious way first. It's also going to be the cheapest way, and it just makes sense to try that approach first before escalating things further. So the first thing that I would do if I were you would be to contact the buyer to see if the buyer will still be open to purchasing the property back. And if I have not already claimed my excess proceeds from the HOA foreclosure, then I'll go and claim that so that I can have some money to work with to do a buyback. If the buyer refuses, which a lot of them will at this point, especially if they've already evicted me or they're about to evict me and they know that my 6-month redemption period has already expired, they will resist or be uncooperative. If the buyer refuses to sell back the property to me, then I will consult a lawyer in my area and see if we can put pressure on the homeowners association somehow. The lawyer will check all of the records and also potentially send a demand letter to the homeowners association to ask for evidence of them sending you all of the required notices, the pre-foreclosure notices as well as the post-foreclosure notice, and the lawyer will also see whether there is an affidavit filed in the records, in the county's property records, stating that they completed the foreclosure according to law, and that will also send you the post-foreclosure notice of your right to review. The lawyer will look at all that, and that lawyer should be able to determine whether you can move forward with a wrongful foreclosure lawsuit based on all the findings. And if you move forward with a wrongful foreclosure lawsuit, you're going to add that buyer to the lawsuit, which is because they're a necessary party, because that buyer's title is clouding your title, and vice versa, because you're disputing everything that happened and you want your property back in your name only. So as long as you've been making a mortgage payment on the back end and there's no threat of a mortgage foreclosure, you have a chance to go and sue the homeowners association and try to get a judge to reverse that sale somehow or wrong the right. And the buyer will still have to be settled. You still have to pay that buyer, you pay that option plus interest. Okay, so those are the options. This is why I would say it's best not to do things until it's too late. Because if you leave things, ignore mail, or refuse to go claim things at the post office and pretend like nothing is happening, and I understand this because we're overwhelmed sometimes. If you continue to do that, though, it lessens your choices. It restricts your options, and it makes things more costly in the end. So because you're not going to be able to successfully do a wrongful foreclosure lawsuit by yourself, you need a lawyer, and your lawyer will so I'm just doing it here to let people know all the rights of the homeowners in respect to the homeowners association foreclosures. Make sure you're familiar with the CCRs, but I can almost guarantee you that most of them are expected to have a power of sale on assessments that are constituted. And some of them will have to go to court to do it. And if they do go to court, remember I mentioned the judicial process, and I said I'll come back to that. The main difference is that in the judicial process, they have to serve you either personally or by other method if personal service did not work. So they have to serve me notice of that lawsuit by a constable or private process server, and if they're not able to find me, try several times, and the lawyers particularly go back to court and ask the judge for substituted service, for the permission to do a substituted service, which is typically like certified in there. And I also post something on my front door. Okay, so when they complete that part, people are really shocked that they don't then tell me anything else that's going on in the case. They don't send me any other letters, notices, or documents. And this can happen only because maybe I missed my answer period and I didn't respond at all to the lawsuit. Maybe I saw the document on the door and I just couldn't deal with it. And I never filed a single thing in the lawsuit. I never filed any letter to court. And I never showed up to court physically. So that means I did not make an appearance in the case. That's what the law says. As long as I failed to make an appearance in the case, the other side is not required to continue to send me notices and documents of anything that's going on in the case. It's almost as if I waived my right to get documents and information about what's going on in the case. So they can essentially set up a final hearing without notifying me if I fail to respond to the service, if I fail to show up in the case. So they can they can ask for a final hearing and then ask the judge for permission to move forward with the foreclosure, which they would get based on the evidence, whatever evidence that they provide, and the judge would grant them an order of foreclosure. So that is the intermediary step between the notice of assessment, meaning that I said usually is filed in the county's records, and the notice of foreclosure sale, which has the date, time, and place of when the auction will take place. So they have to go through the judicial process if their governing document does not allow them to do a non-judicial process. Some HOAs would elect to do a judicial process regardless if they have concerns that they might face liability in the future with this particular homeowner, or maybe if there's an estate involved, meaning that the homeowner died and they're dealing with the heirs now. So just to recap, just all the rights that are there for the homeowners. The first thing to know is that there are notice requirements under the law, so you want to check to make sure the homeowners association follows all of the notice requirements, and then you want to know that if a family member or friend is facing potential foreclosure by an HOA, they do have a right to redeem if for some reason if the foreclosure already took place. They have a right to redeem if they catch it within 180 days of the sale date. If they don't catch it within 180 days of the sale date and they still want to redeem, then they might approach the buyer directly to do a buyback or have a lawyer investigate to see if they could pursue a wrongful foreclosure case. If they can do a wrongful foreclosure case based on the evidence, lack of notices or improper notices, then they have to file that within 4 years of the sale date. And then lastly, I wanted to also remind you that the homeowner has a right to the excess proceeds from the homeowners association foreclosure, which will be the amount left over, the difference between how much they owed and how much the homeowners association received at the auction. They have a right to that. And so these are all the points that I wanted to bring up. If there's anything else I left out, or if there are questions that you'd like me to cover in a future video, feel free to leave a comment below and I'll do my best to cover those. The other question people would have is, well, what about the underlying mortgage? How does that work with all of this? Well, I think I mentioned it before, the mortgage will still be there, but it's not the obligation of the buyer at the foreclosure auction. It's still the obligation of the person that signed the promissory note at the very beginning. So the person that gave an IOU was the homeowner, not the buyer. So the homeowner would still be obligated to pay that, and if they want to walk away completely because they were fed up with all of this and they're happy with the excess proceeds that they received from the homeowners association foreclosure, then they can just walk away, and it will affect your credit at that point, of course, and it's not necessarily the best way to do it. So it will affect your credit if there's a foreclosure. It will affect your credit if you're just late on the payments or missing several months of payment. Hopefully the buyer does not allow the mortgage to go into foreclosure to protect their possessory rights, because they are now likely in possession of that property and they don't want to lose it, so they will end up paying whatever balance is still owed on the mortgage. So a lot of buyers at homeowners association sales don't do their math or their due diligence very well, and they don't realize that their right to the possession itself is subject to the mortgage in the background. And sometimes the mortgage is such a big amount, it's not worth it for them to then try to pay the mortgage and keep the property. Sometimes it is and sometimes it's not. So you have to do your math before you even bid on any property if you're somebody that buys these properties at the homeowners association foreclosure. All right, so I hope this video has been helpful to you guys. And if you have any questions, you can contact us directly if it's a legal question in the state of Texas. And as I always say, these videos are for educational purposes only, so that people can be aware of the rights, obligations, and requirements under the law and things like that. But anything specific to a particular situation, that has to be done through consultation with licensed attorney. So thank you as always, and have a wonderful weekend. I'll talk to you guys next time.